So here we go. We continue from now. So this is an absolutely adversarial, thing that Judge Anderson does to the poor victims of these laws. Now, I have also expressed another bias and opinion of mine, which about these laws. So, you know, for the case of transparency, I feel that a minor who finds herself in this boat is going to naturally want to reach out to her parents in the first place. I can't imagine if I try to put myself in the shoes of somebody like that, or in my head, a teenage girl that gets knocked up and doesn't at least want her mother involved in things, if not her father as well. It is just a reality of youth. I, me, when I was that age, when I was a minor, I didn't tell my parents about my, lovers very much. I didn't tell them very many details about who I was dating. I didn't, they found out about Nur like after the breakup was becoming really a serious thing after like 3 years. Like I didn't tell them much of anything about our relationship. So I mean, I understand that teenagers keep things from their parents all the time, but when I fucked up, when I made really major mistakes as a teenager that put me in serious jeopardy, put my life in danger, or did terrible things to my future, I would relent. And the reason that was because I knew that even if my dad was angry, or an angry person, my mother would always be there for me no matter what. And as angry as my dad would get, he still would just yell, at me and give me a lecture. So that was the worst that I was likely to experience, and it would be a headache, obviously, to deal with him being upset for a very long time, because he was notorious in that when he got angry, he would go on and carry on for hours on end. Would be off doing something else, and he'd still be going off about it, whatever had pissed him off. He just would not stop complaining about it. So like 4 hours later, he'd still be pissed off at you for failing to put away the Nesquik, or leaving it near, where he makes his coffee, and it just got so out of proportion and ridiculous that it became so much of a headache that I had to take to the internet to talk about it sometimes. You'll notice I haven't done that in a long time because he's no longer with us. But yeah, I had to deal with a lot. And if you don't realize this, like, he would get so pissed off sometimes he'd drive the car erratically with us in the back seat. He maybe I'm struggling to find a way to conceptualize this, because like there wasn't a lot of battery, even though it did happen here and there. It usually didn't get physical. It was just that there was just so much, in that department and such. But I learned that if I really fucked myself over, that it was time to kind of swallow my pride and talk with them. And I think that most teenage girls are kind of the same ilk in that regard. I mean, they will keep a lot secret from their parents, but if they find themselves in a really life altering situation where they've been knocked up, they're gonna reach out. I mean, that's just the reality. So why do we need to have a state that's going to force them to? It's so ridiculous to me that they'll, it, it blows me away, because it's like, if they can talk to their parents, if they know that that's the worst they're going to experience, their dad may be a little bit pissed off and he may yell at them a bit, but that's the worst that they're going to go through. They're going to come and talk to them about it. If I knock somebody up, I certainly would. I'd be like, I'm fucked. Now I have to pay child support for the rest of my existence if she doesn't abort this thing. I gotta talk to them about this. This is a thing where I'm gonna need some support. And that is what kills me about the whole thing. because it's like we've got to get the state involved to force them to do it, and people call you immoral for opposing getting the state involved, and I'm just like, I just say what I do because I'm concerned that this compromise is a bad compromise that Elna Silverstein is going over, and on top of that about rape and incest, and it's just abuse, of minors in this whole thing, and that's really what kind of got me going against the parental notification laws, because the thing that exists in my head is this: Helena Silverstein, like at the beginning of the book, talks about a girl that was knocked up by her father and killed later on over it. Like, this is just, these things happen. Parents are not always like the best. They're not necessarily supportive. They're terrible, and it's like we need. Well, in general, like I really do feel like the good parents are gonna get their girl reaching out to them anyways. They don't need the state to legally compel her to do it. And so if girls aren't naturally reaching out, that says something about who their parents are. You know, it really does, and that's what kills me about this whole thing. But anyways, so continuing in this book, it's true that some minors have been granted judicial bypasses despite facing fetal representatives. Indeed, in the notorious Miss Phillips case, Judge Anderson found for the minor. Nevertheless, all well that end well is not the proper conclusion to draw from these facts. Minors who face this judicial innovation are subject to intimidation and delay. It's not unreasonable to think that a minor facing these prospects would consider her alternative, or perhaps find that her interest does not lie in exercising her rights. No one should think that it's permissible for judges to use this bench as a platform for a rhetorical onslaught against vulnerable minors as long as the judges ultimately relent. Judicial browbeating is not mitigated by minors with the ability to withstand it. The law and politics. The constitutional fine print. In the wake of several Alabama appellate court decisions that sustained lower court denials of bypass petitions, Judge Douglas Ng Johnson of the Alabama Supreme Court remarked that the appellate courts of this state will continue to flout the abortion rights of minors unless and until some minor successfully petitions the United States Supreme Court for censorial review. As we have seen this chasm, as we have seen this chasm between our expectations about how the bypass process will function and how it actually functions is wide. And from here, it may seem a short leap to the conclusion that the application of parental consent mandates in Alabama, Pennsylvania, and Tennessee would be found to violate the abortion rights of pregnant teens. In this chapter, I suggest that what at first sight may appear to be a no-brainer turns out at least to be a brain teaser, and in some instances a brain breaker. That it is far from certain that all of the practices described above, from the apparent transparent implementation failures of Part 2 to the judicial gerrymandering of Part 3, would fail constitutional inspection. The court in Bilotti 2 laid out the basic framework for constitutionality sound consent provisions, but since then the court put forward the undue burden standard as the benchmark for reviewing abortion regulations in general, holding that women have the right to choose abortion free from unsubstantial obstacles imposed by the government. What is at stake under the undue burden standard is the meaning of substantial obstacle, and the history of the court's application of this predicate raises serious doubts about whether an airing before the court of practices taking place in Alabama, Pennsylvania would result in the ruling Johnstone expects. The undue burden standard. In 1992, the watershed case of Planned Parenthood versus Casey, the court considered the constitutionality of Pennsylvania's one parent consent mandate, as well as provisions requiring informed consent, a 24-hour waiting period, and spousal notification. Awaiting this much anticipated decision, court watchers wondered whether the justices would jettison Roe in return unchecked authority to regulate abortion to the states. The plurality opinion in Casey, authored jointly by Justices Sandra Day O'Connor, Anthony Kennedy, and David Souter, disappointed pro-life advocates by reaffirming Roe's finding of constitutional right to abortion. The Casey plurality sustained what it described as Roe's essential holding, ruling that the 14th Amendment due process clause includes a right to choose to abort a non-viable fetus without undue interference from the state. At the same time, the plurality disappointed the pro-choice camp by adopting the same undue burden test to fashion the constitutional makeover of Roe. Under the standard of review that had been established in Roe, state regulations of abortion would survive constitutional scrutiny only if they served a compelling government interest. Applying this high level of scrutiny and to the trimesters of pregnancy, the court in Roe held that the state's two asserted interest in regulating abortion, protecting maternal health, and protecting prenatal health do not become compelling until the later stages of pregnancy. The state's interest in maternal health only becomes compelling, the court ruled, when the first trimester ends. The compelling point for protecting prenatal life comes even later, only when the onset of the third trimester, thus thought to be the point of fetal viability, may the state regulate and even go so far as to forbid abortion for the purpose of protecting potential life, though only when such regulations does not interfere with the life and health of the woman. In this refashioning of Roe versus Wade, Casey's court rejected both the trimester framework and the requirement that states demonstrate a compelling interest when regulating abortion, retaining the conclusion that prior to the onset of fetal viability, the state may not prescribe abortion to protect fetal life. Casey nevertheless endorsed the state's interest in regulating on behalf of the life form from the moment of conception. According to the plurality, the woman's liberty is not so unlimited, soever that from the onset the state cannot show its concern for the life of the unborn. By deciding that the Constitution protects a woman's right to choose to terminate her pregnancy prior to viability, the court argued that it does not at all follow that the state is prohibited from taking steps to ensure that the choice is thoughtful and informed. Even in the earliest stages of pregnancy, the state may enact rules and regulations designed to encourage her that there are philosophical and social arguments that of great weight that can be brought to bear in favor of continuing the pregnancy to full term, and that there are procedures and institutions to allow adoption of unwanted children, as well as a certain degree of state assistance if the mother chooses to raise the child herself. The Constitution does not forbid the state, a city, pursuant to democratic processes, from expressing a preference for normal childbirth. It follows that states are free to enact laws to provide reasonable framework for women to make a decision that has so profound and lasting meaning. The authors and Casey thus concluded to promote the state's profound interest in potential life throughout pregnancy. The state may take measures to ensure that the woman's choice is informed. I'm just sitting here like, the state should fuck off. Women are not its property. And measures designed to advance the interest will not be invalidated as long as their purpose is to persuade women to choose childbirth over abortion. Furthermore, discarding the compelling interest standards, the plurality held that the state may advance such measures as long as they do not impose an undue burden on women. And I'm sitting here like, all such things should constitute an undue burden. Jesus Christ. All of it. It's all bullshit. Like, but they get to be the tyrants who define what even constitutes an undue burden, and that is a problem in of itself in this whole thing. And I'm fucking sick of it. Like, just this whole thing is bullshit, and it has been the whole fucking time. It's been crap, but I know that Roe is gone now, and so this book is a little bit out of date in the information that it's pushing, because unfortunately the court has ruled a very, very pig-headed way. I think of the courts as tyrants. I mean, they talk about the state, and it's like, god damn it, you guys are fucking imperialist bootlickers. You want the government to have this kind of overwhelming authority in a woman's life, while your party basically preaches a message of small government and lower taxes, and then it wants to be 17 kinds of up in a woman's uterus. Like, you guys are creeps and tyrants, and it's all fucking sick. And I mean, this idea that the state has a profound interest in the life of the feet. No, it doesn't. It doesn't hurt the United States government in any goddamn way if somebody has an abortion. It has literally no effect, other than the fact that maybe there's one less potential taxpayer. Like, come on. And it is a shorthand for and besides that, the state actually has a compelling interest in that child being aborted because the woman in this case, and as far as the United States government will be financially affected by the tax situation, will actually do better if the child isn't born because having a child confers many tax benefits on people, among other things. It also entitles you to all kinds of government services. And on top of that, the mother will be in better financial shape without the child to do good things and works for the United States government. So actually, the interests of the state are the exact opposite. It's actually of interest to the state that the mother actually abort the child. In fact, the state should prefer that outcome because that is in the best interest of the state as far as the tax picture is concerned. It is a shorthand for the conclusion that state regulation has the purpose of effect of placing a substantial obstacle in the path of a woman seeking abortion of a non-viable fetus. A statute with this purpose is invalid because the means chosen by the state to further the interest of potential life must be calculated to inform the woman that's with free choice, not hinder it. And a statute which, by furthering the interest in a potential life and on some other valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice cannot be considered a permissible means of serving its legitimate ends. Understood another way, we will answer this question left open to a previous evidence discussing the undue burden formulation, whether a law designated to further the state's interest in fetal life. The state has no interest in it. It has an interest in the abortion of fetal life. Jesus Christ. Don't you get it? You'll get more money, so the government does better if she aborts. You're so wrong. The court is fucking wrong here. The Casey court opinions elaboration that the undue burden test and its retentions of certain aspects of Roe aim to weigh a woman's liberty interest against the state's the state's interest in potential life. The state doesn't have an interest in potential life. It does worse if the child is born. So, you know, Casey thus argued that Roe's acknowledgement that the individual in the state's interest of abortion could often collide, but compared to Roe, the balancing act elaborated under Casey's undue burden standard tips the scales heavily in favor of the states by permitting substantially more regulation of abortion. The Casey's decision advances this new balance by explicitly sanctioning the use of abortion regulations to declare a preference for childbirth over abortion. The plurality insists what is at stake is the woman's right to make the ultimate decision, not a right to be insulated from others in doing so. Regulations which do no more than create a structural mechanism by which the state or the parent or the guardian may express profound respect for the life of the unborn are permitted if they are not a substantial obstacle to the woman's exercise of the right to choose. Unless it has that effect on her right of choice, a state-measured designation to persuade her to choose childbirth over abortion will be upheld if reasonably related to that goal. Regulations designed to foster the health of the woman seeking abortion are valid if they do not constitute an undue burden. But what counts as a substantial obstacle? If state has license from the onset of pregnancy to create mechanisms designed to express profound respect for the unborn, to encourage women to forego abortions, and to instruct women on the philosophic and social arguments in favor of pregnancy and childbirth, how far may the state go without crossing the undue burden threshold? The court's application of the undue burden test to specific regulations affords some insight. In Casey, the court sustained two types of provisions that were rejected under the Roe framework in earlier cases. Among these, there was an informed consent requirement mandating the provisions of certain information before abortion may be performed on a woman, minor, or adult. The court ruled that states may require more than the communication of information that pertains to the woman's health, as long as the information provided is truthful and not misleading. The states may insist that doctors inform women of the availability of information related to the consequences of abortion to the fetus, even when those consequences have no direct relation to her health. We permit the state to further its the state just keeps inserting that it has an interest in this stuff, but it doesn't. We permit the state to further its legitimate goal of protecting the life of the unborn by enacting legislation aimed at ensuring a decision that is mature and informed. Even when doing so, the state expresses a preference for childbirth over abortion. Yes, maybe representatives of our government have a preference for this, but that doesn't mean that the state actually has an interest in childbirth over abortion. Just because certain people who work in government have that preference doesn't mean that the state itself is better off, if the child is born. In short, requiring that the woman be informed of the availability of information related to fetal development and the assistance available should she decide to carry the pregnancy to full term is a reasonable measure to ensure an informed choice, one which may cause the woman to choose childbirth over abortion. The requirement cannot be considered a substantial obstacle to obtaining an abortion, and that follows there's no undue burden. So the state should only really have an interest in how much revenue is coming into its coffers. If it gets more revenue as a result of the abortion, then its interest is should favor abortion over childbirth. And that is the reality of the situation. Casey also sustained a mandated 24-hour waiting period between the provision of consent information and the performance of an abortion. The plurality conceded that the waiting requirement has the effect of added cost and delays on the exercise of a woman's right to choose an abortion. The findings of fact by the district court, the plurality explained. See, also, the requiring minors go through all this is an undue burden on the grounds that, it's an expense. They have to travel. Indicate that because of the distance many women must travel to reach an abortion provider, the practical effect will often be a delay of much more than a day because the waiting period requires a woman seeking an abortion to make at least 2 visits to the doctor. Furthermore, the district court found that for those women who have the fewest financial resources, those who must travel long distances, and those who have difficulty explaining their whereabouts to husbands, employers, and others, the 24-hour waiting period will be particularly burdensome. But whether these added burdens are undue, the court concluded, is another matter. Not every law which makes a right more difficult to exercise is ipso facto an infringement of that right. I actually think it is. Unfortunately, the state should have no right to make any law that makes any right more difficult to enact. There should be an amendment that to the Constitution itself that prevents it from doing any of that. It can't make a right even slightly harder under any circumstances, a carte blanche ban on it. And in fact, it should restrict the First Amendment so you can't even express disagreement with that opinion. The government can criminalize that so that you're required to agree. The fact that the law serves a valid purpose is not one designed to strike that's the right itself, has the intended effect of making it more difficult or expensive to procure an abortion cannot be enough to invalidate it. I think it should be. Fuck you. With this principle in mind, notwithstanding the lower court's finding that the waiting period proved burdensome for many women, the court upheld the waiting period. I'm just sitting here reading this. The court would see. I'm fucking sick of it. You guys had I think that it should be easy as fuck to vote, for instance, because I think that literally any restriction that makes it more difficult should be unconstitutional. So all of our voter ID laws out the window. All of it. Bye-bye. The state should be restricted from enacting any law that makes it more difficult to enact any right, and that every law that makes the right more difficult to exercise is an infringement of that right. Ipso facto, and that it isn't proves that the law is the problem and should be updated so that this is the case. With this principle in mind, so hence, on the record before us and in the context of this facial challenge, the plurality explained we are not convinced the 24-hour period is an undue burden. In contrast with the sustained provisions, the Casey plurality rejected a requirement that they receive notification before the performance of abortion. Spousal notification, the plurality held, is likely to prevent a significant number of women from obtaining an abortion. It does not merely make abortion difficult or expensive to obtain for many women and will pose a substantial obstacle. We must not blind ourselves to the fact that there are a significant number of women who fear for their safety and the safety of their children are likely to be deterred from procuring abortionists. Surely, if this is the case, had outlawed abortion in all cases. In attempting to demarcate the boundary that separates permissible from impermissible abortion regulations, Casey ostensibly draws the line between the encouragement of childbirth on one hand and the hindrance of abortion on the other. However, a more plausible, if more troubling, reading of Casey suggests that the boundary sits not between the encouragement of childbirth and the hindrance of abortion on one hand, between the encouragement of child and the discouragement of abortion on the other, the likely provision of state-safe abortions. In other words, on a reasonable ruling of Casey's undue burden standard for an abortion regulation to amount to a substantial article, it must have the purpose of likelihood of stopping a significant number of women from obtaining abortions, or the effect of creating considerable health risk. These women would confront considerable challenges in the face of abortion measures. On this reading, it is not sufficient to find the measures constitutionally flawed. Yeah, and that shows that, there's a problem with the law, which is clearly improper and should be rewritten so that it can. You guys are all fucked. I mean, seriously, what? Seriously. This whole thing has me thinking. First of all, women are not the product of are not ultimately property of the state, so the state should fuck off all the way. And secondly, like I said, the state should not be able to put these, make it harder to exercise a right. That should also be unconstitutional. So all those laws that try to do that, just overturned. We should make an amendment that does that so that the court's hands are literally tied behind their backs and they are required, under the Supremacy Clause to enforce the law, which means that any law that does this will get overturned. And one of the other reasons to interpret cases this way is that beyond inferences that can be drawn from the court's conclusions about how about the challenge Pennsylvania regulations, the plurality says little about how far states can go in persuading women to pursue childbirth rather than abortion. Notably absent from the joint ruling is the treatment of the distinction between persuasion and pressure. Justice Harry Buckman, writing separately, would have limited what the state may do when encouraging abortion, stating that measures must be designed to ensure that a woman's choice is mature and informed, not intimidated, imposed, or impelled. But the joint opinion does not adopt this type of limiting language. Furthermore, while it is true that the plurality declares states may not hinder abortion, the pronouncement runs counter to virtually everything else established in Casey about what states may do with respect to impeding abortion. At least so far as the encouragement of childbirth constitutes a hindrance to abortion, as surely it does, as the joint opinion may be read in permitting states to hinder abortion, as Justice Antonin Scalia observes in commenting on the joint opinion's characterization of undue burden. Obstacle is substantial, we are told, if it is calculated not to inform the woman's free choice but to hinder it. The latter statement cannot possibly mean what it says. Any regulation of abortion that is intended to advance what the joint opinion concedes is the state's substantial interest in protecting unborn life will be calculated to hinder a decision to have an abortion. If the reading I have presented in Casey is a fair one, then the refashioning of Roe is even more extensive than it may initially appear. The license given to states to regulate abortion under Casey is a far cry from Roe, and it is a far cry from Roe, and renders the so-called fundamental right to an abortion much less fundamental than the other rights afforded constitutional protection. This discussion that follows applies my own and seemingly Justice Scalia's reading of the undue burden standard to the empirical analysis demonstrated earlier in this text. Though Casey confirmed Pennsylvania's consent mandate without explicit application of undue burden, relying instead on Bellotti 2, the undue burden test is applicable to parents' involvement regulations. Lower court applications of Casey indicates that such a reading is derivable from Supreme Court precedent. For example, in Planned Parenthood versus Miller, the 8th Court invalidated a South Dakota parental notification requirement based on the undue burden standard. Such an application of undue burden to parental involvement requirements does not come out of the blue. Just 2 years shy of Casey, the Supreme Court used the language of undue burden when upholding an Ohio parental notification requirement. In addition, Justice O'Connor, co-author of the Casey ruling, adopted this language in her concurrence in Hodgson versus Minnesota, saying that it has been my understanding in this area that if the particular regulation does not unduly burden the fundamental right, that our evaluation of that regulation is limited to our determination that the regulation rationally relates to the legitimate state purpose. But this isn't this isn't a legitimate state purpose, is what I'm trying to get at in my general thrust and all this. This is only the purpose of individual actors that work for our government and pretend that because they work for it, that they actually are able to declare what its interests actually are. I mean, I'm sorry, but the state actually has a substantial interest in people actually having abortions rather than, because of the fact that it will actually bolster its coffers. Finally, the Casey does not explicitly argue that the unburdened test to Pennsylvania's parental consent mandate. Neither does it limit application to the test of those regulations of abortions that affect adult women. Like it's all acting like it has a legitimate interest in all of this, but it doesn't. Why the undue burden test reaches parental involvement regulations, it does not replace Bilotti 2, providence guidelines for constructing involvement statutes, but these guidelines are not exhaustive. For example, they do not specify whether the bypass road must be available free of charge, and they do not provide a standard of review for assessing whether the states violate the constitutional right to abortion by charging minors who use the option. The undue burden test supplies the measures for such an assessment, but thereby providing criterion for answering constitutional questions outside the scope of Bilotti 2 guardianship appointments. I begin with an examination of whether the designation of guardians to represent the interests of the unborn at bypass hearings has the purpose of placing a substantial obstacle in the path of a minor seeking abortion. In light of the evidence recounted in Chapter 7, it is undesirable that Judges Anderson and Capel's guardianship appointments grow out of the judicial opposition to abortion. And mind you, these people pretend that they represent the interest of the state, but they're just judges and they're just individuals that are empowered by the state, but people will say they represent the state, but they don't really. They don't. They are using the wheels of state power to basically, assert their own personal preferences and then say it's the state's interest, which is bullshit. By designating guardians to represent the fetus, these judges provide a forum to present the minor with pro-life views that seek to dissuade the minor from aborting her fetus. Is it fair, then, to conclude that Anderson, Capel intend, by appointing guardians, to place a substantial obstacle in the minor's path to abortion? We would surely arrive at affirmative answer to the question were we to appeal to the ordinary sense of the expression substantial obstacle. However, this expression is a technical one deriving substance from Supreme Court pronouncements. These pronouncements include the stipulation that states and agents of the state may create a structural mechanism to express profound respect for the life of the unborn. This is precisely what the appointment of a guardian for the fetus is designed to achieve. The designation of a guardian is aimed at ensuring that a woman's choice contemplates the consequences for the fetus, and this aim, Casey tells us, does not necessarily interfere with the right recognized in Roe. The appointment of guardians in Alabama has forced minors to confront new and considerable challenges, and we can surmise that these appointments are intended in part to make the hearing more difficult. But because we can reasonably cast the judge's primary purposes in terms of encouraging childbirth and discouraging abortions rather than in terms of preventing abortion, Casey makes it possible to conclude that the motivation behind appointing guardians in Alabama is constitutionally permissible. Although the line between encouraging childbirth and preventing abortion is a fine one, this is the line that Casey requires be drawn in determining constitutionality of abortion regulations. Alternatively, a strong case can be made that Anderson and Capel have crossed the line, that their behavior is not consistent with an intent to merely encourage childbirth over abortion, but to prevent abortion. Even if we conclude that Anderson and Capel have breached the undue burden threshold, this would only lead to the conclusion that their guardianship appointments are unconstitutional. Such a conclusion would not prevent a state or a judge or a state legislator with the specific or intended purpose of encouraging childbirth over abortion from requiring fetal representations during bypass proceedings. As long as officials assert their interest in protecting potential life, and this is the problem, the state's officials don't actually get to define what the state's interests actually are. I'm sorry. but its agents are not actually capable of that. I'm sorry. Just because somebody who happens to work for the government says this is the government's interest doesn't mean it actually is the government's interest in reality. And what exists in on paper and in the law does not necessarily constitute a reality beyond the paper of the law. So, the government may on paper say that this is its interest, but it doesn't make it the case. It doesn't translate it magically into reality as an empirical or objective reality. These are individuals that happen to work for the government who are attempting to conflate their own personal preferences with the interest of the state. I'm sorry, but they don't get to define it. If the purpose of fetal representation defines constitutional requirements, then these appointments may yet prove unduly burdensome based on their effect. As we have seen, for the typical waiver hearing, one does not include a guardian ad litem for the fetus. One that does not include a guardian ad litem for the fetus, the minor has to make arrangements to travel to the courthouse, meet with an attorney, go before a judge, all while trying to maintain her anonymity and doing what was already a trying time in a young woman's life. When guardians are added to the mix, the minor still has to make the requirement arrangements to go to court, meet with an attorney, and so forth. But the hearings are longer and have been delayed by cooling off periods and appeals filed by guardians. Additionally, what is in the absence of a guardian is essentially a non-adversarial fact-finding inquiry that becomes an adversarial proceedings with attendant magnification of anxiety. Minors have confronted testimony from pro-life advocates and faced extensive cross-examination from attorneys whose legal mission it is to see that the minor gives birth. Inquiry as to whether the minor is mature and capable of giving informed consent to a medical procedure is expanded to include the inquiry concerning whether she comprehends the philosophical and social arrangements of great weight that can be brought to bear in favor of continuing pregnancy full term. Guardianship appointments make what is already a challenging process all the more challenging. But do the added challenge constitute a substantial obstacle? Again, under an ordinary sense of the phrase, the answer is obviously yes. Like the predicament of the proverbial straw hauling camel, the addition of guardians places one more obstacle on top of another, making the hurdle the minor confronts more difficult to overcome. Nevertheless, under the authority of cases, the added challenges do not unduly burden minors. First, the fact that hearings involving fetal representation last longer than the typical hearings is not enough to invalidate the use of guardians. It ought to be, though, obviously. Although only a few of the hearings have lasted more than 2 hours, and even those delays might withstand constitutional scrutiny, given the court's acceptance of 24-hour waiting periods. With respect to what are now more routine hearings that usually last not less than 90 minutes, the additional time is inconsequential under Casey. Second, my hearings have become increasingly adversarial with the involvement of guardians. This doesn't necessarily constitute an impermissible barrier to abortion. McPhillips may indeed have gone too far in his interrogation, and for the sake of argument, we can grant that his involvement posed an undue burden on that particular minor. Still, Casey does not preclude the adversarial bypass proceedings because Casey permits the state to make women aware that there are strong arguments in favor of childbirth and against abortion. Because guardians work towards this end, their present and the attendant adversity would appear to be acceptable. Third, and maybe the most important, there's little indication that minors have been prevented from obtaining abortions due to the presence of fetal representation. The appointment of a guardian for the fetus would create a substantial burden if a significant number of minors were deterred from procuring an abortion, as surely as if the state had outlawed abortion in all cases. But unlike the case of spousal notification, evidence does not demonstrate at this point that minors have been deterred from pursuing bypass requests. In fact, even with the presence of guardians, minors have successfully petitioned for waivers of consent, and there is no reliable evidence to suggest that minors forego abortion because of guardians. In the response to the above, it might be argued that the orders of the Montgomery court judges requiring such things as cooling off periods are unconstitutional. It might also be argued that the religious overtones of some of these hearings are constitutionally suspect. When direct questioning related to Bible scripture comes into play, so do First Amendment issues. Similarly dubious are questions like the following one proposed by a guardian to a minor. If you did have a complication and you had to go to a hospital, your church or congregation is going to find out what happened. How is that going to affect you're going to church every Sunday? These constitutional concerns are genuine, but beside the point. Such conduct does not demonstrate the constitutional impermissibility of the guardianship appointments themselves. What raises concerns are the religious questions, not the presence of the guardian. Therefore, it cannot be said in light of Casey that the mere appointment of a guardian to represent the fetus has the effect of imposing a substantial obstacle on the minor, which is a bit fucked up. You know, because in this, the state is making an explicit endorsement of a religion. Save a life counseling, whereas current precedent may permit fetal representation, the judicial directive that minors receive counseling from Save a Life Crisis Presidency Center fails constitutional inspection. However, rather than failing Casey's undue burden test, the constitutional infirmity of this requirement owns principality to a violation of the First Amendment's Establishment Clause, so she agrees with me, which provides that Congress shall make no law respecting the establishment of a religion. Given Save a Life's evangelical mission, judges who condition bypass grants on the receipt of counseling from this ministry effectively require religious counseling, thereby violating each of the three legal tests conjured by the Supreme Court to interpret the Establishment Clause, the Lemon Clause, the coercion test, and the endorsement test. In the 1971 case, Lemon versus Kurtzman, the court advanced what has come to be known as the Lemon test to assess alleged breaches of the Establishment Clause. Lemon requires, first, the statute must have a secular legislative purpose. Second, its principal or primary effect must not be the one that neither advances nor inhibits religion. And finally, the statute must not foster an excessive government entanglement with religion. Failure to any prong of this, the Lemon amounts to Establishment Clause violation. So here we go. I think we should sue on this basis against these laws and rulings to satisfy the first prong of the Lemon test. Mandated Save a Life counseling must be motivated by a secular purpose. As we have seen, there are some grounds for suspecting religious views inspire the Save a Life mandate, at least for some judges. Furthermore, there is no doubt that the goal of discouraging abortion is behind this mandate. However, the judges also contend that pro-life counseling, when authored in conjunction with counseling provided by abortion clinic personnel, ensures balanced information on the pregnancy options. It's arguable then that the judges' stated goals stand up as secular, whether or not they arise from some deeper religious conviction. Whether judges ensure balanced information to encourage childbirth, these goals serve a secular purpose and do not obviously fail the first prong of the Lemon test. The mandate does fail the second prong of Lemon. Among the ways in which the government would impermissibly advance religion is when that conduct supports religious indoctrination. The court has said that although the Establishment Clause jurisprudence is characterized by a few absolutes, the clause does not absolutely prohibit government-financed or government-sponsored indoctrination into the belief of a particular religious faith. Such indoctrination, if permitted to occur, would have devastating effects on each individual voluntarily to determine what to believe and what not to believe, free of any coercive pressures from the state, while at the same time tainting the resulting religious belief with a corrosive secularism. Despite this holding, the court has been reluctant in recent rulings to presume that religiously affiliated institutions will engage in indoctrination. So you have this. For instance, the court held in Bowen versus Kender that the Congress may pass legislation directing funds to religiously affiliated institutions that provide education and counseling services to adolescents, and this was a mistake of a ruling. It goes to show you that our court is really fucked up. In deciding the facial challenge, the courts rejected the presumption that such funding would inevitably result in religious incalculation. On what grounds did they reject it? Because obviously it will inevitably result in it. Anybody that's rational knows that. Like, it's completely, utterly batshit insane to think that it is even the faintest, that there's a snowball's chance in hell that they won't. Like, we can be absolutely certain that they are absolutely guaranteed to do it, and that there's not even a slight, remote, faintest possibility whatsoever that they won't. This is crazy. If you think otherwise, you are batshit
lunatic, insane, there's no truth in you, and whatever the basis for your opinion is not how a valid opinion or judgment is reached, and you should feel terrible for thinking otherwise. I don't know on what grounds these people get off thinking otherwise, but it's not a valid one, whatever it is. And we're done.